of the logs here. Otherwise, this ICT expert has put the link in his affidavit, and when he takes the witness stand, when the trial starts, he will demonstrate to you how this system works, and you will see the logs themselves. But to give you a printout, which is a requirement of the rules of procedure, one has to copy the logs and put them here. And therefore, if the logs are copied twice, it does not mean that somebody voted twice. Allow me to take you through the exact entries that my learned colleague, Mr. Wanyama, has alluded to. At page 16 is a log called at 15th of August 2025 at 19:25:29 hours, 7:15 p.m. and 29 seconds. He alleges that there is a vote cast by that IPPD number. And you go to page 17, you see where he's alluding to at the first line, 15th August 2025 at 9:15:29, vote cast by that IPPD number. Let's look at the next log. The next log, 15 August 2015, 19:15:26. Let's go to the corresponding log on the following page, 17, 15th August 2025, 19:15:26. The same hour, the same minute, the same second. Go to the third entry, senators. This is 19:15:23. Then you got the following log, 19:15:23. Failed log, failed log. You see the same entries of the same IPPD number by the same person at the same hour, same minute, same second. This is a product of the copying of the logs for purposes of printing. It is not the logs in the system. It's how when you copy the log to print, you can copy twice. The results of this election, which my learned course will are at pages 21 to page 26 of volume 4A. My apologies, not 26, 28. The results are at pages 21 to page 28. And if you go to page 22, at the second box from the bottom, that is Honorable Chepkemoi Beatrice, you notice she voted yes at 19:15:19, and you don't see her in any other entry in the results of the vote. These are the results of the vote. This is what the speaker declared. You run from page 21 to page 28. You will see every senator, sorry, my apologies, every MCA who voted yes captured once. I juxtapose this data, and possibly, Mr. Speaker, when the members will be contributing, fortunately for us, this Senate is a crucible of talent. There are multiplicity of talent here, and there are ICT experts among you. They will demonstrate very clearly that you can't take a copying of the logs to print when it's copied twice, say therefore somebody voted twice. Otherwise, it will mean that these people were so meticulous that from that entry that Mr. Wanyama began with, up to the second last entry on that page, and when you go to page 17, from the first entry up to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, up to the 11th entry, those people transacted meticulously at the same time, second, minute, hour. It makes no sense. That's number one. Number two, in their submissions, my learned colleagues have said they will call witnesses to prove these facts. It means what they have raised before you are questions about credibility of witnesses. The forum for testing credibility of witnesses is in the trial itself, so that this ICT expert will take the stand, take you through the procedure, take you through these logs and field questions, and then you'll be able to test the credibility. And that will be the case for any other person, including members of the county assembly. I'm making out a case that what has been argued before you is not a preliminary objection by any stretch of imagination of that word preliminary objection. These are contentious, convoluted matters of law, which even you have seen. My learned colleague, Mr. Wanyama, wishes to convert himself into a witness and also tell you how he participated in this voting process himself. We have no problem with that, senators. If my learned colleague, Mr. Wanyama, wishes to take the witness stand and adduce that evidence, we have been here long enough to demonstrate that we deal with that in cross-examination. It is the only tool known to law for testing veracity of evidence. Allow me then to go to the standing orders. Standing order number 77 of the Kericho County Assembly standing orders is the operating standing order for this process. I will also briefly allude to standing order number 83. Standing order number 77 provides that unless the Speaker, for the convenience of the Assembly, otherwise directs, voting on a division in the Assembly shall be by electronic voting. So that the first grievance that my learned colleagues for the governor are raising is, why did the Speaker comply with standing order number 77? That's the essence of the objection. 77.3 provides that during electronic voting, members shall cast their votes by pressing either the yes, no, or abstain button. I sat here and I listened to my learned colleague, Mr. Carter Keegan, most polite colleague that I know, very courteous colleague that I know, saying that the word button means a manual button. A manual button. Technology has evolved. And when an electronic system prompts you with the 3 electronic buttons, yes, and you press it, no, and you press it, abstain, and you press it, I respectfully submit you have pressed a button. So partly, again, this objection was based on a very manual understanding of the word button. And I don't know how much more I can say about that, but I think, Mr. Speaker, senators, that's the best I can do. To say that because Kericho County Assembly has technologically advanced, that people can press electronic buttons as we do with our M-Pesa smartphones, we admit yes or no or cancel without pressing a manual button, or as we do in our ATM machines. The ATM machine prompts you. You select bank statement, select withdrawal, select electronically on the screen. To say that because Kericho County Assembly is at pace with that technology, we must therefore fault it. It will be a sad day in the history of governance of this country if we reached that verdict. So, senators, you have been told that certain MCAs have sworn affidavits distancing themselves from the vote. We have demonstrated that this is not a new game in town. Number one, in the Mike Mbuvi Sonko case, that happened. The court determined the Hansard is the authoritative source of information. The only way to counter that is when those witnesses come here in the trial itself and their evidence is tested. But number two, when you finally look at volume 7A, this is an affidavit of one of the said 18 MCAs denying swearing those affidavits that the governor has brought for you. One of them sworn an affidavit is here before you. Distinguished senators, can we resolve this matter without putting the actual people on the stand at the trial to resolve that matter? I submit respectfully that's impossible. Mr. Speaker, I know my time is up. May I just get 2 minutes to sum up my argument? Mr. Speaker, my apologies, my time is up. I want to just get some 2 minutes to sum up the argument.
2 minutes.
Thank you so much, Mr. Speaker. So, Mr. Speaker, what are we saying in a nutshell? In a nutshell, we are saying that there is a witness affidavit supported by documents running from page 1 of volume 4A, running from page 4 of volume 4A to page 44 of volume 4A, giving you an audit trail of this voting process. Nothing can be a clearer explanation of a verifiable and accountable system of voting than a system that generates this kind of audit trails. So you can't fault a system that can generate this volume of audit trails and say it is faulty. Number two, you have been told that these MCAs are not technologically advanced and could not vote. Pages 1 to page 3 of that volume 4A is evidence of Kericho County Assembly buying for these MCAs laptops to technologically enable them way back in September 2024. Way back in September 2024, and therefore the Assembly has done its part. What is the correct approach to this objection, Mr. Speaker? I suggest that, Mr. Speaker, the matters raised in this objection be subsumed in the trial. This matters be tested through the trial, and this matters be determined as part and parcel of the questions of fact and law that this Senate shall deal with at the voting stage of this motion. I respect Mr. Speaker, and I rest the County Assembly's case.
Counsel for the Governor. Now, Honorable Senators, pursuant to Standing Order 34-2A, I will allow not more than 15 minutes from 1 p.m. to enable the Counsel for the Governor to respond to what has just been submitted to by the team from the County Assembly. You may proceed. You have not more than 15 minutes because the House must rise at exactly 1:15. You need not take the entire 15 minutes. You may proceed.
Mr. Speaker, sir, the first point we wish to observe is that in response to our preliminary objection, one of the issues we raised in our preliminary objection is that the entry credentials, being the use of an ID number as a password and use of payroll number as username, has not been contested. And the emphasis in it is that those two particulars are publicly available. Anybody who works with the county can easily access the ID number and the payroll number, and therefore it should have been possible. Indeed, it happened that other people intercepted the system. And these buttresses the arguments made by my learned friend, Mr. Wanyama, when he pointed out somebody called Peter and others who logged in, including the admin who in the audit report is indicated as having entered, whilst it is the clerk who is said to be the admin of the system. The second argument, Mr. Speaker, sir, I know my learned friend, my learned friend for the County Assembly has tried to belittle the point we are making about the issue of the button and pressing. And Mr. Speaker, sir, and honorable senators, if it was intended that you can use electronic means and not necessarily a device that is secure, then even the Senate would have otherwise had to use a different system. It would have, in place of requiring, first of all, you will recall that the enactment of that Standing Order number 77 was made in October 2024. It is hardly a year ago. And so if the Kericho County intended to be very electronically advanced, then they should have, in place of using the word button, said we will use a link to vote. If it was intended that they should not necessarily press but click to vote, then they should have used the word in that Standing Order number 77.3 to say we will vote by clicking, not press. Mr. Speaker, sir, I insist that the intention of Standing Order number 77.3 was to ensure that there is an accountable, responsible, and verifiable voting system. Mr. Speaker, sir, my learned friend, in response to the arguments we've made in respect to Standing Order number 77, has invited your attention to Standing Order number 80. And he puts emphasis on the prerogative that the Speaker has in allowing the use of electronic voting. In reaction to his invite to you to make reference to Standing Order number 80, we would like to invite you to the standing order that is immediate before the one he has referred to, standing order number 80, being standing order number 79, which says that if MCAs insist that they want to vote by roll call, then the Speaker has no choice, provided there is somebody who has objected and is supported by more than 5 people, is supported by up to 5 people. In this case, Mr. Speaker, sir, we have invited your attention to the fact that there were 18 people who are opposed to this style of voting and wanted a roll call voting. For that reason, Mr. Speaker, sir, it is our argument that the only reason why the Speaker defied the provisions of Standing Order number 79 is because there was intention to fraudulently misrepresent the votes that were cast by the MCS. Lastly, Mr. Speaker, sir, as I hand over to my learned friend, Mr. Wanyama, it is said that this system was secure. And that point is buttressed by the affidavit by the IT expert that my learned friend, Mr. Ongoya, has repeatedly made reference to. And one of the things then that come up for your consideration in our preliminary objection is this. Can we determine for a fact that the 4 MCAs who say they didn't vote indeed voted? And honorable senators and Mr. Speaker, sir, it is my submission that the only way we can determine that is to determine whether the link was sent to that respective MCA and that MCA specifically voted using his number that the link was sent to. And Mr. Speaker, sir, you will see from the audit logs that the audit log does not indicate anywhere the numbers to which the link was sent, nor the IP address of the devices that were sent. And therefore, it goes into the question of the scheme to manipulate these votes. The inverse of that, and the only way that the county could possibly say that they have an absolute answer to the question of whether or not the votes were manipulated, is if they could demonstrate that indeed the link was sent to an individual and that the IP address of that phone gadget was the one that cast those votes. Mr. Speaker, sir, to the extent that the audit report brought to you avoids by design to give you that information, Mr. Speaker, sir, we say creates a doubt in your mind. In closing my part of my submission as I hand over to my learned friend, Mr. Speaker, sir, this is our argument, that indeed there was no voting, and therefore the threshold of 2/3 was not achieved. But as a writer to that argument, Mr. Speaker, sir, and honorable senators, it is our argument that even if, as my learned friend says, there is a possibility that this system was okay, if there is doubt in your minds that indeed this system might not have been foolproof, if there is doubt, that is enough reason for you to decline entertaining and determining this motion. For all those reasons, Mr. Speaker, sir, and honorable senators, we pray that you reject this motion on the basis that you are not satisfied that indeed there was a motion that was properly considered, that it was properly voted for, and that the purport that there were 33 MCAs supporting the motion has been achieved. That's all, Mr. Speaker, sir.
Yeah, Mr. Speaker, sir, I will stick to the time. Just in quick rebuttal, I would like to invite the honorable senators to look at the governor's response at page 113. My colleague, Mr. Ngoya, talked about one MCA. That's the governor's response, page 113. The governor's response, volume 1, at page 113. The governor's response, volume 1, at page 113, because ultimately for the Senate to determine that the motion is properly before it, it must be satisfied on the threshold. From the 47 MCAs in the county assembly, at least the threshold requires that 32 of them vote in favor of the impeachment motion. Now, at page 113, it is true what Mr. Ongoya has said, that one MCA has sworn an affidavit. Principally, they jumped ship, swore an affidavit saying that they didn't meant what they said. But there are 17 other MCAs who have evidence in support of the PO at page 113. 17 MCAs. Ultimately, this is a process that follows the law. The Constitution is the Senate is a house of record, house that follows the Constitution, follows the law and the standing orders, and looks and listens to the evidence. So what is the evidence that I am showing you here? At page 115 is the evidence of 17 MCS who have said they never supported the motion. So what does it mean? Do we have contrary evidence to rebut the cogent allegations by these 17 MCS? If you do a quick calculation, minus 47, minus the 17 from 47, how many numbers do we have? We have 30. Does 30 meet the threshold in section 33(2) of the County Government Act? The answer is definitely not. Do we need to wait for this question to be subjected to trial the way Mr. Ongoya has invited? The answer is no. The evidence is before the Senate to determine the issue. What about the logs? We are relying on the logs given to us by the county assembly. They are the ones with access to the system. They printed it out and submitted to the Senate. We are simply relying on it, and we have pointed out more than 10 mistakes on the logs. Why can't they just do impeachment on the right thing? Why are they hiding in technology, trying to manipulate the votes for purposes of achieving an objective which the Constitution requires a very high threshold? Just to finish, Mr. Speaker, sir, we have also audio evidence, KB1, which we request that when you retire, you can have opportunity to look at it. That is KB1. It just fortifies it fortifies this fundamental point, that we have a problem on this matter that is before the Senate, at the threshold question. One of my colleagues, Mr. Speaker, sir, asking if we can play the audio. We have time for the audio. With your permission, can we play it?
Proceed. You have 2 minutes to do that. The Senate will rise at exactly 1:15.
Yes, we are requesting that KB1 be played. Sorry.
Mr. Speaker, subject to your guidance, I'm just wondering whether introduction of new evidence in this matter, I'll be able to respond to it, because that's now new evidence.
It is part of the bundle. Yes. It's part of the evidence that is already on record.
Because we can't comment on it once they have played it, but we could have commented on it, Mr. Speaker. If they had played it earlier, then we can comment in our response.
Just proceed and play the video.
Yes, Mr. Speaker, so we request for the KB1 to be played by the ICT staff.
We urge more counties to do their own ERP system just the way they are doing. It is something that has made the county work efficiently in terms of their elections.
Don't waste time. You're giving the out of the country, Wendy.
Your Honor, the screens, Mr. Speaker said the screens are off. There was a transcript. Yeah.
Don't waste time. You're giving the out of the country, Wendy. Is ready. Kifutani ina bread sign and affidavit ko rone agi bet in fact oda muja demone 200,000 agi kabisa
Ochawakso.
Imache ana iwendi.
Jeba kaki muta bidati. Aki biru baka wadu pai. Bari kiwo lawa fore na mugi mo.
Dubai muti mache kini ma muche cho.
Ami resap kabisa. Kimi ak lawa kyukwe.
Mache ngero yawe. Na ge ma cho. Wale si. Kaza ngibe. Na mora. Oya jabru kura otiana.
Go biru angure?
I'm using it because of you.
Hey, but the good anda yun. Yeah?
I don't go in to governors.
Hey.
Deny it.
Yeah? Yeah. Come on, Rurun. Yeah, thank you, bro. Come on, Lini. Do it.
You are defending a governor, the give
Ara isn't it the other?
Yeah, Joey, we have that. I don't believe it. I never lived in the this Javlang. We get to go on very job. I can swear the Capitol.
Time is up.
Yes, Mr. Speaker, sir. Thank you.
I'm afraid
thank you very much
transact beyond 1:15.
Thank you very much, Mr. Speaker, sir.
Now, Honorable Senator, just take a seat. Take a seat. Take a seat. I will deliver my ruling at exactly 2:30 today on the matters that have been raised. Senate, arise. Honorable Senators, it is now 1:15 p.m. time to adjourn the Senate. The Senate therefore stands adjourned until today, Wednesday, 27th of August 2025 at 2:30 p.m. That are associated Finch Focus Limited, Jomax Holding Limited, and Benlock Ventures Limited. F. Payment vouchers for Health Services Department made to the following: Afroscape Limited and Slick Solutions Limited. Payment vouchers for water, energy, environment and forestry, and natural resources made to the following: Jebema Construction Supply and Rowley Ventures Limited. Report on the pending bills by Committee on Ad Hoc. Report by the Committee on Water and Environment on Flocker projects. NVC DP report by the Committee on Agriculture, Livestock and Fisheries. Ad Hoc Committee report on Kazi Mutani. Report by the Department of Finance and Economic Planning, Strategic Intervention Phase 2, and 2 photos and 4 affidavits, 1 judgment and 1 ruling. Ad Hoc Committee report on Londiani incident, Auditor General's report, correspondence between the Governor and the Speaker dated the 20th of August 2024 and 3rd of September 2024, certified copy of a list of members with signatures in support of a motion for removal of the Kericho County Governor. I think I've gone back to that. R, advertisement for vacancies by County Public Service Board, an internal memo on redeployment of staff under the Health Service Department, a Facebook extract, and letters of termination. Ad Hoc Committee report on alleged fictitious payment, voucher for Megro Products Limited, retention, other companies that were paid retention money, evidence of public participation. That is an extract of the Standard newspaper advertisement for public participation on notice of motion for removal of Dr. Eric Ipkoech Mutai, the Governor of the County Government of Kericho, by impeachment. Number 2, a scanned memorandum and submissions received in response to the notice of motion for removal of Dr. Eric Mutai as governor of Kericho County. Number 3, a public participation register for the collection of memorandum forms, and 4, a report of public participation. Governor's response and volume 1 and 2, Kericho County Assembly standing orders, a flash disk containing video evidence, and 3 transcripts. Now, pursuant to Section 33(3) of the County Governments Act and Standing Order 81A, at a special sitting of the Senate held on Wednesday, the 20th of August, 2025, the charges against the governor of Kericho County, as contained in the motion of impeachment by the County Assembly of Kericho, were read out to the assembled Senate. Honorable Senators, ladies and gentlemen, as you are aware, the mandate of the Senate in relation to proposed removal from office by impeachment of a county governor is provided under Article 181 of the Constitution, as read together with Section 33 of the County Governments Act 2012. C, abuse of office or gross misconduct, and D, physical or mental incapacity to perform the functions of office of county governor. Number 2, Parliament shall enact legislation providing for the procedure of removal of a county governor or any other grounds mentioned in Clause 1. Section 33 of the County Governments Act 2012, Standing Order 80, and the third schedule to the Senate Standing Orders provide for the procedure to be followed in the hearing and determination of the proposed removal from office by impeachment of a county governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may, either by resolution, appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Now, honorable senators will recall that at a special sitting of the Senate held on Wednesday, the 20th of August, 2025, the motion for the establishment of a special committee was withdrawn pursuant to Standing Order 70 for failure to be seconded. This withdrawal paved the way for a default position, the hearing of the impeachment charges against the governor of Kericho County, to be held in plenary. Now, honorable senators, ladies and gentlemen, by way of a status update, pursuant to Rules 4A and 6 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate invited the governor to appear and be represented before the Senate during the investigation. The Senate further invited the governor, if he so chooses, to appear before the Senate to file an answer to the charges with the office of the clerk of the Senate by 5 p.m. Monday, 25th of August, 2025, setting out the following: the governor's response to the particulars of the allegations. Number 3, the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. Number 3, the names and addresses of the persons to be called as witnesses, if any, and the witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And 4, any other evidence to be relied on. Honorable senators, you may walk in and take your seats. Now, honorable senators, pursuant to Rule 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor or a deputy governor in plenary, the Senate notified the Kericho County Assembly of the date for the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and be represented before the Senate during the investigation. The County Assembly was further invited, if it so chooses, to appear before the Senate to file with the Office of the Clerk of the Senate by 5 p.m. Monday, 25th of August, 2025, the following documents. Documentation 1, designating the members of the County Assembly, being not more than 3 members, if any, who shall attend and represent the Assembly in the proceedings before the Senate. Number 3, indicating the mode of appearance and by advocate. 3, indicating the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate, and specifying any other evidence to be relied on. Now, honorable senators, ladies and gentlemen, on Monday, the 25th of August, 2025, the Office of the Clerk of the Senate received a response dated the 23rd of August, 2025, to the invitation to appear issued to the Governor from Messrs. Katwa and Kemboy advocates, who indicated that the Governor had appointed the firm to represent him in the hearing before the Senate. The letter also indicated that the Council represented the Governor and the list of witnesses for the Governor. Counsel for the Governor also indicated that the Governor would appear before the Senate in person and by advocate. Similarly, on Monday, the 25th of August, 2025, the Office of the Clerk of the Senate received a response, reference number H&K, /009, /017, /2025, and dated the 24th of August, 2025, to the invitation to appear issued to the County Assembly of Kericho County from Messrs. H&K Law Advocates, who indicated that the County Assembly of Kericho had appointed the firm to represent the County Assembly in the hearing, and that the County Assembly would also appear in person and by advocates. The letter also indicated the Council represent the County Assembly and the list of witnesses for the County Assembly. Now, pursuant to Rule 8 of the Rules of Procedure when considering the proposed removal of a governor in plenary, the Clerk of the Senate furnished each party with the documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Now, honorable senators, ladies and gentlemen, the hearing program, which has been appended in today's order paper, details the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial, therefore, that all the parties comply with the time allocated. The parties will be notified of the balance of time on each activity through the digital clocks mounted on the clerk's table. In summary, the program states that today, the Wednesday, 27th of August, 2025, after we have dispensed with the preliminary matters, the charges against the governor shall be read. The governor will be given an opportunity to take a plea on each charge. This will be followed by an opening statement by the County Assembly and thereafter by the governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence and shall not exceed 5 hours. At the sitting scheduled for tomorrow, Thursday, the 28th of August, 2025, honorable senators will be given an opportunity to ask questions or seek clarifications from the County Assembly. Thereafter, the governor will have an opportunity to present his case before the Senate. The presentation shall also not exceed 5 hours. Honorable senators will also be given an opportunity to ask questions or seek clarifications from the governor. At the sitting scheduled for Friday, the 29th of August, 2025, the closing statements by the parties will be made for a period not exceeding 1 hour each. The Senate shall then proceed to debate prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. In accordance with Article 123 of the Constitution, the County Governments Act 2012, and Standing Order 86 of the Senate, the voting by the county delegations, the voting shall be by county delegations. The governor shall cease to hold office if a majority of the county delegations in the Senate vote to uphold an impeachment charge. If, however, the vote in the Senate fails to result in the removal of the governor, pursuant to Standing Order 87, the Speaker of the Senate shall notify the Speaker of the Kericho County Assembly accordingly. Honorable Senators, ladies and gentlemen, I now invite counsel for the County Assembly of Kericho to introduce the legal team of the County Assembly and the members of the County Assembly of Kericho representing the County Assembly by stating the full name and the designation of each person. Counsel for the County Assembly, you may now take to the floor.
Good morning, Honorable Speaker. Good morning, Senators. Good morning, Honorable Mutai, Governor Kericho. For the County Assembly of Kericho, the representation is as follows: Vincent Kiprono, Joel Wahungu, Elvis Kipkorir, Evans Kiblangat, Victor Kibet, Geoffrey Langat, Brian Langat, Hilary Kiblangat, Elias Mutuma, the Sharon Mibey, who is an advocate and also the Deputy Clerk of the County Assembly, Elisha Ongoya, being the lead counsel, and myself, Kimutai Bosek. There is also the following honorable members from the Kericho County Assembly. The mover of the motion, Honorable Kiprotich Rogony. There is also Honorable Albert Kipkoech and Honorable Vincent Korir. Thank you, Honorable Speaker, sir.
And now, similarly, I now invite counsel for the governor to introduce your legal team representing the governor.
Mr. Speaker, sir, honorable senators, Your Excellency the Governor Kericho County, and my colleagues, good morning. With the permission of my senior colleague, I wish to introduce to you the legal team representing the Governor Kericho County. First, I wish to confirm that the Governor Kericho County, Dr. Eric Mutai, is before the House, and the legal team led by Senior Counsel Katwa Kigen, joined by Counsel Peter Wanyama, assisted by myself. My name is Doris Ngeno, and Counsel Wanjiro Thiongo, Counsel Joash Mitei, Counsel Evanson Kirui. That is our legal team. Thank you for the opportunity to appear before this honorable House.
Senator Fernandez, take your seat. Honorable Senators, on behalf of the Senate, I now welcome the team for the County Assembly, the team of the Governor, members of the public and the media, to the Senate and to these proceedings. Finally, I now invite the clerk to call the next order and thereafter to read the charges against the Honorable Eric Mutai, the Governor of Kericho County.
Order number 2, reading of the charges on the proposed removal from office by impeachment of the Honorable Eric Mutai, Governor of Kericho County. The Honorable Dr. Eric Kipkoech Mutai Governor, Kericho County, please take the stand. Honorable Dr. Eric Kipkoech Mutai, Governor, Kericho County, the charges against you as received from the County Assembly of Kericho are as follows, and I quote, Ground 1, gross violation of the Constitution and other laws, gross violation of the Constitution of the Republic of Kenya 2010, the County Governments Act 2012, the Public Procurement and Asset Disposal Act, the Public Finance Management Act 2012, and Kericho County laws. The particulars of this ground are as follows. Allegation 1, misappropriation and misallocation of county finances. On various occasions since his election as a governor and subsequent assumption of office, the governor has engaged in various acts of gross violation of Articles 10, 183, and 201 of the Constitution, Sections 102 and 109 of the Public Finance Management Act, Cap 412A, and the provisions of the Kericho County Rating Act, number 5 of 2019, as follows. 1, fictitious payment of works, goods, and services. Between January 2025 and July 2025, the governor engaged in gross violations of Articles 10, 183, 201, 207, and 208 of the Constitution, and Sections 102, 109, and 110 of the Public Finance Management Act 2012, and Section 3, Subsection 3, Section 30, Subsection 3F of the County Governments Act 2012. The governor aided, abetted, and or condoned the fictitious payment of goods, services, and works which were neither delivered nor done, occasioning the county loss of Kenya shillings 85,704,522.90 in A, services which were not rendered and or partially done, for example, the maintenance of 15 residential houses in Kipkelion West Sub-County at a cost of 2.99 million shillings. B, goods not delivered, including soya beans, maize jam, sunflower, seed cake, and cotton seed cake, alleged to have been supplied for Kenya shillings 14,980,640. C, overpriced goods, including sodas, alleged to have been bought for about 500 shillings per 300 milliliter bottle, and a bale of tissue paper, alleged to have been bought for Kenya shillings 2,750 per bale of 10 tissue papers, and a hand towel priced at Kenya shillings 3,600. D, works, goods, and services alleged to have been procured for Kenya shillings 5,172,715.60 from companies including Mengro Products Limited, Hildama Construction and Supplies Limited, Brisac Construction and Supplies Limited, for misappropriating county funds through double payments. 2, some of the goods, services, and works were procured without following the procurement processes. No tender opening committees were formed, contrary to Section 78 of the Public Procurement and Asset Disposal Act 2015, as read together with Regulation 25 of the Public Procurement and Asset Disposal Regulations 2020. Similarly, there were no professional opinions done to the accounting officers, contrary to Section 84 of the Public Procurement and Asset Disposal Act 2015. 3, there was deliberate circumvention of competitive tendering of the same goods, services, and works by splitting of contracts to suit the request for quotation method, therefore violating Section 54 of the Public Procurement and Asset Disposal Act 2015, as read together with Regulation 43 of the Public Procurement and Asset Disposal Regulations 2020. 4. Most of the goods, services, and works were procured outside the approved budget as required under Section 44, subsection 2A of the Public Procurement and Asset Disposal Act 2015. 5. The documents used by the departments were not clear and did not bear references to the procurement requirement, provision of dates, especially invoices generated, and signatures of respective officers. There was therefore blatant violation of the provisions of Regulation 68 of the Public Procurement and Asset Disposal Regulations 2020. 6. No market survey was conducted as required under Regulation 43, Sub-Regulation 4 of the Public Procurement and Asset Disposal Regulations 2020. The contractors therefore supplied goods with exorbitant prices, contrary to Section 54, subsection 2 of the Public Procurement and Asset Disposal Act 2015. 7. All of the subject goods, services, and works were paid for in advance, yet the county has accumulated pending bills over the last 3 years of Kenya shillings 1.1 billion, which have been verified and are yet to be paid from the time the governor assumed office. 8. The report of the ad hoc committee on the alleged fictitious payments tabled before the Assembly on 5th of August 2024 made pertinent and damning findings and recommendations that point to the deliberate failure to act, neglect of duty, and even conspiracy on the part of the governor, to wit, A, the documents shared with the ad hoc committee by the departmental heads called to testify were not accompanied by the ETIM's invoice. This lends credence to the suspicion that the documents may have been prepared to cover up the theft after the whistle was blown. B, the payments were made in advance before goods, services, and works were delivered or done, and as at the date of the tabling of the report, some of those goods, services, and works remained undelivered to date. C, documents that were used to process payments bore the signatures that could not be authenticated. Subsequently, certain officers whose signatures appear in the said documents have denounced the documents. D, the gaps highlighted in the report point to serious governance concerns and weak internal controls in Kericho County that the appointing authority, that is the governor, policy makers, accounting officers, and indeed all the officers entrusted to deliver services to the county have failed to do as required by law. E, there was an intention to defraud the county and violations of the Constitution 2010, the Public Finance Management Act 2012, the County Governments Act 2012, the Leadership and Integrity Act, the Powers and Privileges County Assemblies Act, the Public Procurement and Asset Disposal Act 2015. 9. Under Article 179 of the Constitution and Section 30, subsection 3F of the County Government Act 2012, the governor has the overall responsibility of being accountable for the management and use of county resources. 10. It is a matter of public notoriety that when the whistle was blown on these fictitious payments, the governor, on 26 July 2025, while attending a function at Kamolok village in Cheboin ward, rubbished the claims and called for stern action against the whistleblower. This shows someone who is either unaware of the happenings in the county or was deeply involved in the scandal. 2. Misappropriation of National Agricultural Value Chain Development Project, NAVCPD funds. 11. On various dates between the year 2023 and 2025, the governor has violated the provisions of Articles 10, 183, 201, 207, and 208 of the Constitution, and Sections 48 and 159 of the Public Finance Management Act 2012, and Section 30, subsection 3F of the County Government Act 2012 by aiding, abating, condoning, and/or overseeing the massive looting, pilferage, misappropriation, and misallocation of NAVCDP funds amounting to over Kenya shillings 351 million as at 10th June 2025. 12. From the report of the Committee of Agriculture, Livestock and Fisheries and Cooperative Management, Tourism and Wildlife on the implementation status of National Agriculture Value Chain Development Project, NAVCDP, in Kericho County, tabled in the County Assembly on 6th of August 2025, the County Assembly noted the following discrepancies in the use of the fund. A. The expenditure was used for farmers' cooperative societies, found only in 19 of 30 wards in Kericho County. This implies that the funds that were meant for agripreneurs, whose role was to enumerate farmers and organize them into SACCOs, was not adequately utilized. B. Each ward SACCO was meant to get Kenya shillings 1 million, yet the committee found that out of the 19 SACCOs under the program, only 7 have ever received financial support since the inception of the fund. C. It is further indicated in the report that some SACCO received nominal support in kind in form of office furniture and some farm inputs, while others have never received any support. D. Even those SACCOs and farmer producer organizations which received support in kind did not receive delivery notes when the furniture, computers, and other supplies were delivered, and they cannot therefore ascertain the prices, source, and therefore quality of what was supplied. E. The procurement of furniture and equipment under the NAVCDP program was conducted centrally with minimal involvement of key stakeholders. This does not only undermine the principle of transparency in procurement, decision-making, and lack of ownership, but also created room for pilferage and misappropriation of the fund. 13. The office furniture and equipment supplied under the NAVCDP program are largely of substandard quality. There was therefore no value for money and compliance with the Public Procurement and Asset Disposal Act 2015, particularly Section 124, which obligates the procuring entity to select quality and cost-based selection, QCBS method, as the preferred method to be used to evaluate proposals. 14. The manner in which the few projects which were implemented was done shows that they were done without following the project implementation manual published by the World Bank to guide the implementation of the projects. 15. Again, the governor shirked his overall responsibility under Article 179(4) of the Constitution and Section 30, subsection 3F of the County Governments Act 2012 to be accountable for the management and use of county resources. 16. There is evidence that the governor has been ordering withdrawals from the fund for reasons other than those for which the fund was created by the donor. Evidence of this shall be availed at the hearing and consideration of this motion. The mover will as well be asking the Assembly to issue an order under Article 195, Subarticle 2B of the Constitution, and Section 27, subsection 1C, and subsection 2 of the County Assembly's Powers and Privileges Act 2017, compelling the relevant banks where the funds were drawn from to furnish this House with the bank statements showing the withdrawals of the funds from 2023 to date. 3. Misappropriation of funds and unfair distribution of projects under the Financing Locally Led Climate Action, FLOCA Fund. 17. On various dates between the year 2023 and 2025, the governor has violated the provisions of Articles 10, 179, 183, 201, 207, and 208 of the Constitution, and Sections 102 and 107 of the Public Finance Management Act 2012, and Section 30, subsection 3F of the County Governments Act 2012, by presiding over unfair, skewed, and nepotic distribution of projects under FLOCA funds, imprudent use, misappropriation, and misallocation of FLOCA funds as follows. A, skewed and unfair distribution of projects under the fund, with the governor's home ward, namely Chemosot ward, alone, getting projects worth Kenya shillings 21,701,590, while there are many other wards, not only in other sub-counties, but even in the Bureti sub-county, which have received not a single project under the fund. This nepotically skewed distribution of projects under the fund violates the national values and principles of governance under Article 10 of the Constitution, and in particular, the values of equity, non-discrimination, equality, good governance, integrity, transparency, and accountability, the principles of public finance under Chapter 12 of the Constitution, as well as the provisions of Sections 102 and 107 of the Public Finance Management Act, which enjoins the governor to ensure fiscal responsibility and adherence to the values and principles of the Constitution in the management of the county funds. B, the Joint Committee on Water and Sanitation and Environment, Energy, Forestry, and Natural Resources, in their report on the implementation status of FLOCA programs, noted that some projects under the fund, namely Chemomul Water Project in Kabianga, water and environment projects in Seretut, Chepto Roriet Ward, Torachtani Cooperative Society Milk Cooling Plant in Kapsaos Ward, Soliat Water Tree Nursery Establishment Project in Soliat Ward, Arndonyo Mare Borehole Water Project, and Lelaitich Water Project in Soliat Ward are marked as 100% complete, yet there are either defects in the works, incomplete, and substandard works. 18, as a result of this unfair distribution of projects, wards like Cheplanget, Litain, Chaik, Kipchebor, Chilchila, and Kunyak did not get even a single project in all the categories under the fund, namely environment, agriculture, and water. 4, misappropriation of county funds and Equalizer Kazi Mtaani initiative. 19, on or about 31st of August 2023, the governor engaged in gross violation of Articles 10, 183, 201, 207, and 208 of the Constitution, and Sections 102, 109, and 110 of the Public Finance Management Act 2012 by launching a program dubbed Equalizer Kazi Mtaani initiative and drawing county funds towards the initiative without a legislation to anchor the initiative, public participation, prior approval of the County Assembly and the Controller of Budget, and prior approval of the Budget and Appropriation Committee's approval. 20, under the fund, a total of Kenya shillings 39 million were paid without proper tendering, local service orders, and for the services which were not delivered. 20, the County Assembly's report on the ad hoc Committee on Kazi Mtaani project pointed out various violations of the Constitution and the law in the rolling out and implementation of the initiative. However, the governor deliberately disregarded the report, and it has hitherto not been implemented. 22, the deliberate failure, omission, and unwillingness to implement the report of the County Assembly on Equalizer Kazi Mtaani initiative undermines devolution, the doctrine of separation of powers, and is therefore antithetical to the values and principles of governance under Article 10 of the Constitution, the objects of devolution, and under Article 174 of the Constitution. 5, misappropriation of funds under the Strategic Intervention Projects, SIPs. 23, in various dates during the financial year 24-25, the governor engaged in gross violation of Articles 10, 183, 201, 207, and 208 of the Constitution, and Sections 102, 109, and 110 of the Public Finance Management Act 2012 by overseeing misappropriation of various projects under the Strategic Intervention Projects CIP Fund. 24, for instance, the project for upgrading of Kunyak Dispensary to Health Center, which is a retender project for the construction and renovation of various facilities within the health center by Messrs. Belitra Enterprises Limited for Kenya shillings 44,756,846, a total of Kenya shillings 8,575,186 has been paid for no works done. Indeed, when the County Assembly's Committee on Implementation visited the site, they found that the contractor had only supplied materials, contrary to the Finance Department's report to the Assembly that kitchen and staff house was at walling stage, while the MCH is at slab level. 6, other violations of the Constitution and the law. 25, the present and former Chief Executive Committee members and chief officers have variously reported coercion by the governor to make financial allocations for the governor's own use from the funds allocated to their respective departments, and which funds they were required to remit through the governor's personal assistants. 26, violation of Article 201A, D, and E of the Constitution 2010 on principles of public finance, and Article 226 as read with Article 227 of the Constitution by presiding over glaring irregularities evidenced by A, irregular award of contracts and evasion of accountability, B, willfully interfering in the procurement processes and the award of tenders, C, skewed tender awards to various contractors at inflated rates and in collusion with fraudulent contractors and suppliers, D, irregular implementation and unfair distribution of various programs in the county, E, intentionally and negligently presiding over massive theft of county public funds as evidenced by the Auditor General's reports for the preceding financial years, which have raised red flags over various projects. 27, on 15th August 2023, the governor compensated the victims of Londiani accident from the County Emergency Fund to cover up for the funds raised by the public and misappropriated by a committee he had formed to steer the funds drive, and without a cogent explanation of how the funds publicly raised for the victims had been expended. Allegation number 2, misappropriating and or abetting misappropriation of the funds publicly raised for the victims of Londiani accident. 1, on various dates between 4th July 2023 and 9th July 2023, the governor grossly violated the provisions of Article 10, 73, and 75 of the Constitution and Sections 29 and 34 of the Leadership and Integrity Act 2012 by A, overseeing misappropriation of the funds raised for the victims of the horrendous Londiani Junction accident tragedy, in which over Kenya shillings 9 million of public raised funds were lost. B, reneging on his undertaking to implement the report of the County Assembly's ad hoc committee formed to probe the misappropriation of funds meant for the victims of the accident. There is evidence that the governor filed a suit and or supported a suit by those implicated in the report of the County Assembly's ad hoc committee in Kericho Employment and Labor Relations Court petition number E006 of 2023, Dr. Wesley Bor and 5 others versus the governor, Kericho County Government and others, and Kericho ELRC petition number E014 of 2023, Victor Tum and others versus the Governor, Kericho County and others. C, being personally and directly complicit in the flawed award of direct tenders for service providers during the fundraiser and requiem mass of the victims of the accident. D, the county governor has in this regard committed numerous and various acts in the course of his duties that are contrary to and in violation of the Constitution and the laws of Kenya. These include: 1, the authenticity of various payments made cannot be confirmed. The fact that the exact amount of money expended from the sum collected during the fundraiser points to impropriety and suggests a clear fraud on those whom the funds ought to have benefited. 2, a total of Kenya shillings 13,682,660 was collected at the fundraiser. A sum of Kenya shillings 423,000 was purportedly expended as pastor's facilitation, transport refund, field preparation, lunches and refreshments, printing, publishing, and radio announcements. Other payments that were approved from the fund were Kericho County Referral Hospital, Kenya shillings 2,037,524, Londiani Hospital, Kenya shillings 1,534,190, Supertix Limited, Kenya shillings 2,945,000, Supershine Limited, Kenya shillings 411,000, Raise Hotel, Kenya shillings 100,000, County Commissioner's Fuel, Kenya shillings 300,000. 3, that when Kenyans from all walks of life voluntarily made contributions to aid the victims of the tragedy, it was never intended or anticipated that the funds would be misappropriated with the blessings of the governor, who had a higher calling to ensure the money is accounted for to the last coin and on whom the people bestowed their trust. 4, the governor issued contradictory statements insofar as the use of the funds is concerned. The contradictory statements point to his being complicit in the matter. 5, while the governor is on record indicating that the medical bills for all the victims would be waived and taken care of by the county government, it is clear why money had to be paid out from the fund, behave in a manner that avoids conflict of interest between personal interests and